Now, one of the commissioners I'm talking about, I'm from Tamil Nadu, Chief Information Commissioner from Tamil Nadu. Now, one of the commissioners, information commissioners, is from the education department. Therefore, he knows almost everybody. When a question is raised, when the matter comes before the information commission for inquiry, the person recognizes the PIO and just says, hello, how are you? The matter ends there. But the petitioner, the second appellant, takes off and then says, you will be biased, and starts calling names. For the simple reason, this is the person who punished him when he was the director of school education. So language not very becoming in any commission, this and that, and the person who told nothing about it, he walks out, point one. Then he comes to the Chief Information Commissioner. This happened before I joined. Comes to the Chief Information Commissioner, and the Chief Information Commissioner says, I don't think this behavior is permitted. He starts abusing him also and walks out. Now, here, is there a provision? We keep talking about the PIOs. Yes, every law is, every section of the RTA Act can be used for taking them to task. But now, in this case, now these instances are increasing. The trend is increasing. In fact, one gentleman came and told me, you have no powers of contempt which the High Court has. So you can do nothing. I can call you names, I can shout at you, but you can do nothing. He said in so many words. That, of course, we are discussing only. What do we do? What do we do under those circumstances? In fact, let me quote one. In one instance, I said the behavior in my order. The behavior of this gentleman, the conduct of this gentleman is totally unbecoming. He is contemptuous of the commission. And hence, no petition shall be entertained from him henceforth until he tenders an unconditional apology. Whether it is right or wrong is a debatable point. This is one thing which I just did. I just leave it to you. You can just react.
I just want to tell you that even the group take action under the Contempt of Court Act, but many times we simply ignore them. There are. I mean, it's not only activists or a particular category. There are people, categories people who would create problem for the commissions. And what you said is correct. Perhaps this was done in the respect of. I'll tell you. There is a lawyer who suffered some, I don't know what happened to him exactly, but he got mentally affected. He's mentally affected. And he used to come to the High Court every day. And then he would, at exactly sharp 10:30, he would say something against so many persons like Prime Minister and everybody. He had some serious problem. He's a practicing lawyer, but he is, I think something went wrong with him. But then we tolerated him, and finally we said that he should not be permitted to enter the court precincts. So he is not permitted. There's some such way you'll have to find out. But one more thing I would like to. You said that when the commission said hello, etc. To that. I will tell you a very interesting story. This was, if I remember it correctly, this was from Prophet Muhammad. This is a story, or maybe it's part of, the subsequent literature. So this is it is said that the caliph and there was a dispute between caliph and some citizen. So they went to a arbitrator's house, and there as soon as they reached there, the arbitrator, welcomed the caliph and offered him a cushion. So it is said that no, this is the first rule, that it should not be, justice not only is done, but it should be received to have it done. So that independence, that distance has to be maintained, even though, to know of the PIO, etc. And just a small comment on that. Perhaps this was not the reason for that cannot be justification for the applicant to misbehave on this ground. But these are the basic etiquettes.
And we give him a.
and this is one. Anyway, now, ladies and gentlemen, we are already behind schedule by about nearly an hour and 15 minutes. Now, this current session is about Section 8 and other forms of denials, including voluminous information layer. Let me say that I am just about 2.5 months old as the CIC, and therefore I cannot claim to know quite a lot, but still I can talk certain things about it. Now, by way of introductory remark, I am making one observation. Many of you may like it, may not like it, but still it does not matter. Like the right to information is something like a line to be drawn between, let us say, the Harry Potter's invisibility cloak, where nothing is seen, everything is opaque. Or we have the modern days total body scanners in many of the airports, where everything is seen. While nothing is seen, the second it is obscene. So we have to draw a line between this and that, wherever, and that is what this section provides, different layers by which we can stretch up to. And this is only an introductory remark. I would like to listen to you. Many of you are much more experienced than myself. But there are certain safeguards which you will have to take, especially if it involves certain economic activities. I did come across two cases there. Without naming the case, let me say that a particular gentleman, an officer from the government, he was involved in a particular activity. So he was placed under suspension, and then subsequently a vigilance case was instituted against him on various grounds. Now, he wanted that very detail which is required to be furnished before the High Court, so that he can say that he is being harassed by the government for etc., etc., etc. Now, the records were summoned and found that this individual himself was involved in certain transactions which would have a larger impact on the economics of the state. Do we give or not give? This is a real dilemma. The High Court on the one hand wanted those information, whereas the furnishing of such information would really be detrimental to the economic interests of the state. I said, no, we will not give. I went through the entire documents and said, we will not give, despite the High Court being involved in the case being pending. I just stop here, let me listen to you, and then we will discuss further. Thank you.
We had promised, Mr. Chairman, with your permission, that we would take on board, and Colin, I think you're still on track with that, any inputs that they might have about their expectations, which we started. Right. I want to spend 5 or 7 minutes on that, and then is that all right with you? Thank you. So we had put across what our expectations were. If anybody has any further expectations from this group which are reasonable, I would say, what is the phrase, speak up now or forever hold your silence. So in the next 5 minutes, if anybody has any further agenda points to suggest, let's get them on board, and then let's get on with the agenda. Okay, I was hoping nobody did, but yeah. Sorry.
Motivated now to plug up this expectation. Maybe in the evening, this evening, or at some point of time beyond this session, if we can have a small open session to discuss the nuances of the CPC and also the other laws which are Evidence Act, etc., etc. It will be very, very beneficial to me actually. I can guarantee that. And if there are others, then we can join and we can have a small gathering to discuss that.
Yeah, that could be a dinner subgroup, Colin.
Yes.
You leading the discussion.
Yes. Yes. In fact, after this, those who are interested, we're having dinner at the Human Rights Law Network office close by. So we'll have an early dinner and discussion first and dinner.
The CPC and evidence.
Nuances.
Sure.
I think one thing that's been left out, which when we talk to commissioners, when I talk to commissioners, I do feel that commissioners have expectations from civil society, or they feel there are genuine problems in the way civil society or activists approach RTI. Whereas it is fine, yes, the commissioners must respond to what civil society wants. if you want a better dialogue, it may not be a bad idea for the commissioners to say the problem they see with civil society. I mean, like he did mention one, but there are other problems that commissioners do voice. Typically, it's done in a closed room, only between commissioners. I think it may not be a bad idea for us to discuss these also.
Can there we talk?
One moment.
Sir, I am Vikram Singh from Karnataka. Sir, you elaborated the various deficiencies in the interpretations of the orders. My one good suggestion, which I feel, is that can we have a peer review with all the information commissioners?
Peer review.
Peer review.
You mean in this workshop?
Not in this workshop, a regular feature.
Can we discuss about some orders which some of information commissioners gives? They discuss everything except RTI. I have got a very peculiar, funny order from CIC. If I am allowed, I can.
Not right now. You know, there is a sensitivity in discussing specific orders because these are quasi-judicial bodies which would not like to discuss specific. See, if it's their order, they can't discuss. If it is somebody else's order, then also they can't discuss. So it's not going to be a very good thing in this forum.
I don't want to discuss about the orders. Whether the orders under RTI, whether these orders are at all wanted or not.
Okay,
Can information commissioner gives that you give us this refund, you apply for this, you apply for that, without giving that the information which has been sought must be given.
Yeah. Well, let's keep this as a general principle and see if it fits into the thing. I'll try and make sure it does.
Yes, I am Gunavardhan from Kerala. See, my expectation mainly is since this is a judicial colloquium, and there are so many eminent lawyers and similar knowledgeable persons there are, some clarifications which the commissioners can also make use of. Can I cite an example? It is regarding Section 8 itself. See, in Section 2E, the word competent authority is defined. Section 2E. In Section 8D and Section 8E, again, the word competent authority comes there, where the definition given in Section 2E may not be most appropriate to apply. So I would like the forum to discuss if it is found possible.
There is withdrawal of applications during hearing by the applicants, whether under coercion or in agreement with the concerned department before the commission. So that is, creating a problem as it is nearing to penalty. Applicants are withdrawing.